afternoon. I'm Miriam Becker-Cohen, and I'm the Douglas T. Kendall Fellow at the Constitutional Accountability Center. And today I'm going to talk to you about a case called Caniglia v. Strom, in which the Supreme Court held oral argument earlier this morning. The case presents the question whether police officers should be permitted to enter people's homes without a warrant when they engage in what's known as community caretaking. I'm going to start by giving you some background about the case before I talk a little bit about the oral argument earlier today. So starting with some basic principles. The Fourth Amendment protects people's rights to be secure against unreasonable searches and seizures. And one of the chief mechanism that it uses to protect those rights is the warrant. Police officers apply for a warrant by swearing under oath that there's probable cause for the search or seizure that they seek to execute. And then a neutral magistrate judge assesses whether there's probable cause and if so, signs off on the warrant. The warrant requirement really acts as a check on police discretion, and it prevents abuses of power that could occur in the heat of the moment. So the community caretaking exception to the warrant requirement, it has its origins in a Supreme Court case called Katie v. Dombrowski. That was a case involving a car specifically. The court upheld a warrantless search of a car based on the fact that the car was in police custody. It wasn't on the premise of it wasn't on the premises of the person who owned it, and they basically said when a car is impounded, they can conduct a warrantless search to remove contraband from the car that might fall into the wrong hands before the car is able to be secured for the good of the community. So the decision is really fundamentally based on the fact that cars are at the bottom of the Fourth Amendment totem pole. So in contrast, people's homes are at the top of the Fourth Amendment totem pole. The Supreme Court has consistently over the years held that warrantless searches of people's homes are unreasonable per se. We at CAC, we filed an amicus brief in this case that really details how the text and history of the Fourth Amendment reflect the heightened privacy expectations within the home, and also how the history of the Fourth Amendment and its development demonstrate a real need to cabin police discretion through guardrails and narrowing principles, particularly in the context of searching the home. Yeah, it's important to note that there are certain narrow exceptions even to the rule against warrantless searches of people's homes. Those narrow exceptions, particularly as relevant here, are the exigent circumstances exception and the emergency aid exception, which can come into play when police feel they need to have a reasonable basis for entering a person's home because that person has either been seriously injured or is an immediate threat or imminent threat of being injured. So, but the community caretaking exception for the home, at least as framed by the court below, it's a little different. It would allow police to search the home when they're engaged in any activity divorced from the investigation of a crime, such as responding to a noise complaint or performing a wellness check. And the police believe they need to enter a person's home for the good of the community, but that needs not so immediate as to fall into the exigent circumstances or emergency aid exceptions. And the important thing to remember is that the question's not whether police will ever be able to enter a home in those scenarios. It's whether police can do it without getting a warrant first. So just to give you a very highly abbreviated summary of the case below, basically the police entered the home of Mr. Caniglia, and they seized Mr. Caniglia for a mental health evaluation, as well as 2 guns that he lawfully possessed. And they executed this search and seizure without a warrant and without consent, based on Mr. Caniglia's wife's earlier report that she was concerned about her husband's well-being. They had gotten into a big fight, and she thought he might be suicidal. But by the time the police conducted the warrantless search and seizures, over 12 hours had passed since the fight, and Mr. Caniglia at that point was calm and measured. He told police that he would never commit suicide. And the court below upheld that the warrantless search and seizures under the community caretaking exception They acknowledged that Mr. Caniglia posed at least no immediate threat to himself or others, but they said that the police acted within what they called the realm of reason. So moving on to the argument at the Supreme Court this morning, I'll start by saying that just all the justices really did seem to agree that the privacy interests in the home are paramount under the Fourth Amendment, and the community caretaking exception created in KDV Dombrowski doesn't really cleanly map onto a case like this one involving the home. But it wasn't entirely clear what that means for this particular case and for balancing the different interests at stake. It seemed like most of the justices agreed that there needs to be some sort of limit on police discretion, and that the community caretaking exception, at least as crafted by the court below, is too broad. So that was somewhat encouraging from our perspective. At the same time, the court also seemed eager to adopt a rule that would allow police to enter people's homes, even when the threatened injury or loss of life is not going to occur in a matter of minutes, but when the police think their action must be taken immediately. This ended up being more or less consistent with the position that the federal government took during oral argument. They argued as amicus curiae for the respondent, and took a slightly narrower position than the respondent. The hypothetical that kept coming up during oral argument was the case of an elderly neighbor who is never late, who fails to show up for dinner and isn't answering her phone. The justices wanted to know, can police go in without a warrant? How long do they have to wait? How do they get a warrant? Why do they need a warrant? These were all questions that fairly came up, and it seemed possible that the justices might view the current emergency aid exception as embracing that hypothetical, and that they might use this case to clarify the scope of the emergency aid exception, maybe expand it in certain ways, or clarify what they've meant by emergency aid in previous cases, rather than creating a sweeping new exception. Another important thing to note is that the hypotheticals posed by the justices, they generally focused on situations where loss of human life was at risk or serious injury, as opposed to more nebulous and potentially petty things like noise complaints or nuisances. Justice Sotomayor, she repeatedly emphasized that point, and for that reason, she seemed to think that the seizure of Mr. Caniglia himself was more justified than the later seizure of the guns after he was already out of the house. And several of the justices, including Justice Gorsuch, seemed to be looking for some sort of common law rule to link to the exception to the warrant requirement that the respondents were asking for. So anyway, we'll be watching this case closely to see what the court does. Now, before we break, I just want to make sort of three last points related to what I've told you that really bear on what's at stake in this case. First, it's undeniable that today police are called upon to perform a wide range of duties, perhaps duties that people in other professions might be better equipped to perform. And that's especially true in poor and marginalized communities. But as we explained in our brief, the increased presence of police in people's daily lives really cuts against, not in favor, of expanding police discretion to enter people's homes without the independent check of a neutral party like a magistrate judge. Second, expanding the power of police to enter people's homes without a warrant really does open up the door to the horrific police abuse and violence that we hear about all the time, particularly in communities of color. Recent data shows that most police killings in the year 2020 began when police responded to mental health crises, traffic violations, and other non-criminal or non-violent circumstances. And third, as I said earlier, if the Supreme Court were to reject the sweeping community caretaking exception adopted by the court below and applied to people's homes, in our view, they wouldn't be tying police's hands. Police could still enter people's homes in situations that might fall under the community caretaking rubric. They just would have to get a warrant first. And as I explained earlier, there are other exceptions to the warrant requirement that would allow police to act immediately in true emergencies. So the way the court decides this case could have a tremendous impact, not just for Fourth Amendment jurisprudence, but also for real people who interact with police in their daily lives. So to learn more about this case and to read the brief that CAC filed in this case, as well as some of our briefs in other cases, please visit our website at www.theusconstitution.org. Thanks so much for joining me today.